Good
afternoon, Your Honor.
Good afternoon. Patty, can you lower that camera so I can see?
Yes, sir. I said I can. How would the camera? Can you not just turn it?
I'll turn it down towards you. Where is it? Here.
What I'm doing. There you go.
All right, thank you. That'll work. All right, court is on record in cause numbers CR 25-19, CR 25-160, CR 25-220, State of Texas versus Cedric Earl Thompson. Mr. Thompson, I see that you're going to enter a plea to your case to stay in the court. So if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you, sir. You can lower your hand. Your name is Cedric Earl Thompson, is that correct?
Yes, sir.
And Mr. Thompson, are you a United States citizen who reads, writes, and speaks English? I'm sorry, I didn't hear you. Are you a United States citizen who reads, writes, and speaks English? Okay. And in this, in cause number CR 25-19, you are represented by your attorney, Miss Shanna Stein Fallhaber. Are you pleased with Miss Stein Fallhaber as your attorney?
Yes.
Are you pleased with the work that she's done as your attorney?
Yes.
Do you have any questions about any of the paperwork that you've read over and signed today?
No.
Right. Miss Stein Fallhaber, have you or do you believe that your client, Mr. Thompson, is competent today? And if so, that he's entering into this plea agreement intentionally, knowingly, and voluntarily after having been fully apprised of his legal rights?
Yes, Your Honor.
All right. And I see here, Mr. Thompson, of your three cases, it appears that you would be pleading guilty to cause number CR 25-19, which is a possession of a controlled substance in penalty group 1, greater than 4 grams, less than 200 grams. That being a second-degree felony does carry a range of punishment of not less than 2 years in prison, up to a maximum 20 years in prison, and a possible fine not to exceed $10,000. I see that the plea agreement in the case is, upon you pleading guilty to that charge, the state's recommending that court hear the evidence, that the court accept your plea of guilt, find you guilty, and assess your punishment at 10 years confinement in prison, the Texas Department of Criminal Justice, ordering you to pay restitution in the amount of $1,448.79. In addition, you would be responsible for court costs of $290, reimbursement fees of $35, and the state's also recommending that you be assessed a fine of $1,000. And as part of this plea agreement, the state would be asking the court to dismiss the other two charges, which are both possession of controlled substances and have been indicted. Mr. Thompson, is that your understanding of the plea agreement?
Yes, sir.
Right. And Ms. Stein Fallhaber, how much credit time would your client be entitled to against this sentence?
For this case, Your Honor, I believe it was 3 days.
3 days total? Okay.
For the original case. That's the one you're being sentenced to. Yeah, so you only get credit for that.
All right. And Ms. Stein Fallhaber, is that your understanding of the plea agreement as well?
Yes, Your Honor.
All right. And you do believe your client is competent and you have apprised him of all of his rights, correct?
Correct.
All right. Mr. Thompson, let me ask you, how do you plead to possession of a controlled substance in penalty group 1 greater than 4 grams, less than 200 grams?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
Mr. Thompson, has anyone threatened you, forced you, or pressured you to plead guilty to this crime?
No.
All right, the court will accept the defendant's plea of guilt at this time. Is there any objection to the admission of the stipulation of evidence into evidence?
No, Your Honor.
All right, court will admit the stipulation into evidence and take judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor. Thank you very much.
Is there anything further from the defense?
Nothing further.
All right, then the court's going to review the evidence at this time. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement and the recommendation. The court hereby convicts the defendant, Cedric Earl Thompson, of possession of a controlled substance in penalty group 1 greater than 4 grams, less than 200 grams. Court assesses punishment at 10 years confinement in the Texas Department of Criminal Justice. The court orders Mr. Thompson to pay restitution in the amount of $1,448.79, court costs in the amount of $290, reimbursement fees of $35, and the court assesses a fine in the amount of $1,000. Further, the court does dismiss under section 1245 cause numbers CR 25160 and CR 25-220, both possession of controlled substance cases. The court hereby awards Mr. Thompson 3 days credit towards his sentence for the time that he has spent in jail on this charge. Mr. Thompson, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you be fingerprinted. And then once you are released from custody from prison, if you've not paid off your fines, court costs, restitution, and those things, you need to report back here at the Van Zandt County Courthouse so we can make a payment arrangement to have you discharge those things. Otherwise, you could be rearrested for non-payment. Do you understand?
Yes, sir.
All right. Thank you, Mr. Thompson. I'm going to have you step over to be fingerprinted.
Think you may be excused?
Yes, ma'am. Thank you. Appreciate you being here.
Absolutely. Thank you. Take care, Cedric.
Yeah, no, you.
Thank you.
I don't make you walk. I know you're injured. You see what? No. This will call, right? Relax.
Yeah.
Yeah. The pressure out. Thank you so much. So I see just this. Yeah. That's you. Love you. Awesome.
Yeah. Take off of safe.
You know.
All right, sir. Are you Mr. Casillas?
I am, Your Honor, yes.
Okay. All right. I'm going to go ahead and call the cases for Mr. Joshua Jones. This is cause numbers CR 25-206, 207, and 208. State of Texas versus Joshua Caleb Jones. It looks like we are set for pretrial in all three cases. Any announcements on whether or not there's any discovery issues or requests for contested pretrial motions?
At this moment, Your Honor, there's no question that we have been given the discovery. I was curious as to what the current bond amounts are, and I was wondering if the DA could inform me of that.
Yeah, give me just a moment to look it up.
Thank you.
Let's see. So for the assault on a peace officer charge, it's 100,000. For the burglary of a habitation, it's 50,000. Escape while arrested, 25,000. Unauthorized use of a vehicle, 10,000. Burglary of a building, 10,000. Resisting arrest, 5,000. For a total of 200,000.
And I've only the three, police, the peace officer one, the burglary of the habitation, and the escape. Are those the only ones that have been filed so far? Because I only have three cause numbers.
That's correct.
Okay. So he would need to make bonds to those.
Right. So a total of 175,000 for the indicted cases.
And is there a plea recommendation?
We're working on gathering all the facts and everything, but we will be in contact with you with a plea recommendation.
Thank you very much. I appreciate it.
Yes, sir.
Mr. Casillas, any contested pretrial motions at this time? Otherwise, if there's not, I would set the case for docket call in all three cases and give you and the state an opportunity to plea negotiate.
Thank you, Your Honor. Yes, we would move it to docket call, and we have no contested pretrial motions to worry about at this point.
Okay. If you have your calendar with you, Mr. Casillas, I have 3 dates in January, January 6th, January 8th, January 20th. You could have your pick of any of those three.
Your Honor, we would like January 8th, please.
All right, very well. Court sets Mr. Jones in for docket call in each case on January 8th at 1:30. Should Mr. Jones make bail in his cases and be released, then his hearing would automatically move to the same date, but at 9 a.m. We do non-jail cases in the morning and we do jail cases in the afternoon. So January 8th at 1:30, he makes bail, it'll become January 8th at 9 a.m.
Thank you, Your Honor.
You're welcome.
They would be excused, Your Honor.
Yes, sir. Thank you, Mr. Casillas.
Thank you. This is Shane. Is that Shane?
No, that's the account.
Yeah, I say.
Come on, Mr. Jones. You doing
Yes, thank you.
Thank you.
it?
Your Honor, do we have the Spanish interpreter yet? And Polly, I think, is ours this afternoon.
No, not yet.
Okay.
That's it.
Your Honor, can we have 3 minutes?
Yes, ma'am. Are we going to be doing the extradition today?
Yes, but
She's
I
not.
don't believe, no,
Okay, that's fine.
the extradition, Atlee.
That's fine. We do it later. I was just, if she was in there, I was going to go ahead and take care of it. All right, court will stand in recess till you're ready.
Your Honor.
Yes, ma'am.
Okay, we're ready.
Good afternoon, Mr. Schmidt. Who are you ready on?
Judge, I'm ready on all my folks. We can follow them through if you like.
You want to go down the list or you want to go in a certain order?
On the list, be fine.
All right, Nicholas Barden, CR 25191. Mr. Barden is set for pretrial today. Go ahead.
That's correct, Judge. We don't have any contested motions on file at this time. Need a docket call setting for Mr. Barden.
All right, this morning we were setting you on the 20th. You want that same date or do you want the
That'll be fine,
6th?
Judge.
20th?
Yes, sir.
All right, court sets Mr. Barden then for docket call January 20th at 1:30.
I can't keep.
This is Jordan Holloway.
Right, this is cause number CR 25-204, CR 25-225, State versus Jordan Lee Holloway for pretrial. Go ahead.
That's correct, Judge. No contested pretrial. We're received an offer that we intend to accept. We'd ask to set him either Thursday or on the 16th of this month. I don't know if Miss Abney's already booked up on papers for Thursday or not, but we can do it that day if she can.
I think the 16th might be easier, Your Honor. I know we're still working through some paperwork to be ready for Thursday.
16th is fine. All right, court will set Mr. Holloway for plea on December 16th at 1:30. CR 24-275, State versus Benjamin Colin Carnes for docket call.
Judge, we'd have to set it.
Sorry, there's also cause number CR 24-276. Go ahead, Mr. Schmidt.
We'd like to set him for a plea on 12/16.
All right, court sets Mr. Carnes for plea December 16th at 1:30. And Ms. Taberham, Ms. Beal has checked in on the interpreter.
We're ready on him as well. So yeah, you're good.
Yeah, let's do that. What's the
Yes.
that's Martinez Arazo.
That's correct.
All right. So Ms. Taberham, okay, there she is. Go ahead and bring Holly in. They call me speak Chinese today. All right, Ms. Beal, if you'll raise your right hand, I'm going to place you under oath. If you'll go ahead and state your name and license number for the record. Ms. Beal, do you solemnly swear or affirm that you will make a true translation of the statements of the court, the attorneys, and the testimony to be given by the witness in this matter to the best of your skill and judgment? So help you God. All right, court calls numbers CR 25-166 and 167. State of Texas versus Warben Ariel Martinez Arazo. Mr. Martinez Arazo is set for docket call today. Mr. Schmidt, any announcements?
Yes, sir. I was able to meet with Mr. Martinez Arazo a few weeks ago with an interpreter, and we've gone through all of his legal options, I suppose, the best way to say it. We're prepared to accept the state's offer. We'd ask to set him for a plea on the 16th.
All right, very well. Court will set Mr. Martinez Orazo in all three cases, including CR 25-168 for plea before the court on December 16th at 2 p.m. And we will make arrangements to see if we can have Miss Bill's services. Miss Bill, is that something you could schedule today, or will we need to go through the scheduling? Is there another time we can make it later if we need to, if it's more convenient for you to do it later? December 16th, be 2 weeks from today. And if we need to make it earlier, closer to 1:30, we can do that as well. All right, we'll set it for 2 o'clock and you be here at 2:10. That'd be great.
Thank you.
All right.
So,
Does he have any questions for Mr. Schmidt or the court?
¿Tienes preguntas? Sí tenía preguntas sobre del
Is it a question for his attorney or for the?
para el abogado.
okay. We'll save the question.
Okay, he said just let him know he'll address it with him outside of court.
Okay.
All right, be back at December 16th at 2 p.m. And thank you, Holly. I appreciate you being here and scheduling that for us also. Yes, yes, ma'am. Thank you. Good to see you.
No me revisaron a mí y me agarraron con muerta y mediación. Y por favor, check the next side. We're on the bus. I'm going to call these side. Okay, cool, guys.
All right. Thank you for letting us get that in there, Mr. Schmidt. Let's see. We go back to our list. Mr. Mark Anthony Martinez, I believe.
Yeah.
Cause number CR 25-97, CR 25-122. State versus Mark Anthony Martinez. Mr. Martinez is set for pretrial.
That's correct, Judge. We don't have any contested pretrial at this time as per doc call.
All right, court will set Mr. Martinez for docket call on January 20th at 1:30.
ABC. Okay.
Samantha Main,
No females in here yet.
no females, okay.
Well, one female, but not my female.
Okay, what about Morris Moreno?
He's ready for plea, Judge.
All right, cause number CR 24-240, CR 24-241, State versus Morris Lee Moreno. Let me look for my plea here. Is that a plea you did today, Mr. Schmidt, or was this previous to today?
It was, yeah, I submitted the paperwork about 20 minutes ago.
Here we go. Looking, before we get going, and this could be off the record, looking at the judgment under the special findings, I don't see any destruction or forfeiture language. Was that the intent
Yes,
of the parties?
yes, Your Honor. The firearm was never recovered.
It was not recovered.
Correct.
Okay. All right, very good. All right, Mr. Moreno, if you'll raise your right hand, I'm going to place you under oath.
Great.
Mr. Moreno, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes,
All right. You lower your hand. Is your name Morris Lee Moreno?
yes, sir.
Mr. Moreno, are you a United States citizen who reads, writes, and speaks English?
Yeah,
Have you ever been diagnosed with a mental condition?
no,
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney?
yeah,
Do you understand everything that you've read and signed that's in your plea agreement?
yeah,
Do you understand everything? Do you have any questions about anything before we go forward?
no,
Right? Mr. Schmidt, do you believe Mr. Moreno to be competent? And if so, have you explained to him his rights regarding the case? And do you believe he's entering into this agreement intentionally, knowingly, and voluntarily after having fully been apprised of his legal rights?
Yes to all questions, Judge.
All right, Mr. Moreno, in cause number CR 24-240, you are charged by indictment with a second-degree felony offense of aggravated assault with a deadly weapon. That does carry a range of punishment of not less than 2 years and not more than 20 years in prison, and a possible fine not to exceed $10,000. I see that there is a plea agreement. Upon you pleading guilty, the state's recommending that the court consider the evidence, convict you of the offense, and assess your punishment at 8 years confinement in prison, along with a $1,500 fine, court cost of $290, and reimbursement fees of $120. And the state would be asking the court today to dismiss a charge of unlawful possession of a firearm by a felon. And also they're rejecting a case that's been submitted for prosecution, which is a burglary of a habitation. In addition, you would receive credit time towards your sentence for any time that you spend in jail on this cause. How much credit time is it, Mr. Schmidt?
352 days.
352?
Yes, sir.
All right, Mr. Moreno, is that your understanding of the plea agreement and what you're asking the court to approve?
yeah,
All right, at this time, Mr. Moreno, I'd ask you, how do you plead to aggravated assault with a deadly weapon?
guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yeah, I'm guilty.
And has anyone threatened, forced, or pressured you to plead guilty?
No,
Court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the evidence being admitted?
No objection.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Your Honor, only that state is in compliance with victim services. Victim impact statement was sent out and not returned.
Thank you, Mr. Hartwell. Mr. Schmidt, anything else from the defense?
No, sir.
All right, the court is going to consider the evidence at this time. All right, the court, having reviewed the evidence, finds that there is enough evidence to convict the defendant of this offense. The court will follow the plea agreement. The court hereby convicts Morris Lee Moreno of aggravated assault with a deadly weapon. The court makes an affirmative finding that a firearm was used as a deadly weapon. The court assesses punishment at 8 years confinement. The Texas Department of Criminal Justice orders the defendant to pay a $1,500 fine. Court also orders court costs of $290, reimbursement fees of $120, and the court does dismiss under section 1245 unlawful possession of firearm by a felon, cause number CR 24-241, and the court finds that the state is agreeing to reject as part of this agreement DA case DA 2024-1055 burglary of a habitation. Court hereby awards Mr. Moreno 352 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Moreno, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Once you're released from prison, if you've not paid all your fines and fees, you need to show up at the courthouse and ask for a payment plan.
Yes. Oh, yes, sir.
All right, Mr. Schmidt, if you want to get your next client, I'm just gonna sign this while you do.
Yeah. Mr. President.
Oh, sorry. Yeah. 129 off now.
Is Mr. Russell?
No, this is Mark Shirkey.
Okay. All right, court call CR 25-158 and 159. State versus Mark Adam Shirkey. We're set for docket call. Go ahead, Mr. Schmidt.
Yes, sir. We'd asked to set him for plea on 12/16.
All right, court sets Mr. Shirkey for plea on December 16th in each case at 1:30.
Isaiah.
Court calls cause number CR 23-20, State versus Isaiah Ernesto Valencia Fulton. On the state's motion to revoke. Go ahead.
Judge, we'd asked for that 12/16 plea date.
All right, court will set the defendant for plea December 16th at 1:30.
Do you have the paperwork on Mr. Holly? I mean, Gary Russell.
Yes.
No doubt, Rick.
Court call CR 15-106, State of Texas versus Gary Calvin Russell. Mr. Russell, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you, sir. You can lower your hand. Is your name Gary Calvin Russell?
Yes, sir.
Mr. Russell, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No.
You're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done as your attorney?
Oh, yes, sir.
Do you have any questions about your paperwork, that is your plea agreement that you've read over and signed today?
That was from all because.
Mr. Schmidt, do you believe Mr. Russell to be competent? And if so, have you explained to him his rights regarding this case so that he's entering into this agreement intentionally, knowingly, and voluntarily after being fully apprised of his legal rights?
Yes, sir.
All right, Mr. Russell, I see that you were originally charged by indictment with an offense of driving while intoxicated with a child under 15 years of age. That is a state jail felony offense. I see that the plea agreement today and the recommendation is upon you pleading guilty to that charge. The state's asking that you be prosecuted under section 1244A of the Texas Penal Code, which means that if the court accepts the agreement, you would be prosecuted as a felon, but punished as a misdemeanor at 66 days confinement in the county jail, for which you would receive credit for time served already. You would also be assessed a $4,000 fine and restitution of $60. In addition, court cost of $290 and reimbursement fees for your court-appointed attorney and other fees at $530. Mr. Russell, is that your understanding of the plea agreement?
Yes, sir.
All right, then, the range of punishment for a state jail felony is not less than 6 months or more than 2 years in prison. Range of punishment for an offense prosecuted under section 1244A as a class A misdemeanor is not more than 365 days confinement in the county jail. So the court finds that this proposed plea agreement does fit within the legal range of punishment. Mr. Russell, how do you plead to driving while intoxicated with a child under 15 years of age?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Mr. Russell, has anyone threatened, forced, or pressured you to plead guilty?
Oh, no, sir.
All right, then the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the evidence being admitted?
No objection.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, the court's going to consider the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. Court will follow the plea agreement and recommendation from the state. Court hereby convicts Gary Calvin Russell of driving while intoxicated with a child under 15 years of age. Court assesses sentence under section 1244A of the Texas Penal Code at 66 days in the county jail. Court will award Mr. Russell credit for 66 days of time already served in the jail. The court assesses a fine in the amount of $4,000 and restitution in the amount of $60, reimbursement fees of $530, and court costs in the amount of $290. So, Mr. Russell, when you are released from the jail, you need to report to the courthouse so you can make arrangements to pay your fines, court costs, and fees. If you cannot pay them all in full at once, then you can request a payment plan for which the court will grant to you. Do you understand?
Oh, yes, sir.
Failure to do that could result in you being rearrested for violation of the court order. Do you understand?
Yes, sir.
All right. You're hereby remanded to the custody of the sheriff so you can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted with the deputy.
Mr. Solis. Judge, I've got a couple left, but Michael Anthony Solis is Mr. White's client. Mr. White can't be here. Asked me to.
Sure. Yeah. Give me a moment. Let me sign the paperwork and then we'll get with Mr. Solis. Mr. Hartwell, Mr. Schmidt, back on Mr. Russell's case. On the judgment under the special findings regarding the DWI traffic fines, it says it gives the court the option of either finding, not finding, or withholding a finding regarding a waiver of the DWI traffic fine. The fact that it's being assessed would be does not find, correct?
Let me take a look at it, Your Honor, and I'll.
Sure. Well, here, let me share my screen. I'll show you.
Oh, okay.
Maybe that'll make it easier. I don't think I've seen that one yet, so just a second.
Correct, Your Honor. I believe it would be does not find.
Yeah, that's what based on what I saw, the plea agreement to be up here, that's what I thought it would be, but I wanted to make sure that.
Right, and I assume that 4,000 was the super fine, so it would be does not fine.
Yeah.
Right.
Yeah, so here's the 3,000 traffic fine under 709. Okay.
Yes, sir.
And I'll make sure that I check that off. Okay. Give me just a moment. Let me finalize that. Right, this is cause number CR 25-00013, State of Texas versus Michael Anthony Solis. Court finds that Mr. Solis is represented by the Honorable Jeff White. Mr. White had informed the court that he could not be here today due to medical appointment. And the court finds the Honorable Richard Schmidt is standing in for Mr. White. Mr. Schmidt, Mr. White had indicated to the court previously that Mr. Solis was going to be set for plea, I believe, sometime after Christmas was going to be the request. He relayed the same to you.
He did not, Judge. He had indicated to me this morning that he had filed some pretrial motions. And that he gave me a little bit of a mixed message on that he needed a docket call setting. So I'm not sure what pretrial motions he's filed and whether they need hearing, but I think he had a similar conversation with Mr. White this morning.
Yeah, so Mr. White typically files 3 of the same motions, and they're usually carried to trial. So
Yes, sir.
not contested motions. So perhaps he intends to negotiate or enter a plea after Christmas was my understanding. So court
He
will
definitely said docket call.
Yeah, court will set Mr. Solis then for docket call on, I think we may have some. Patty, do you know if Mr. White is already set on the 6th? I want to say that he is, but
Your Honor, it was the 8th.
was the 8th?
Yes, sir.
Okay, good. Thank you, Mr. Hartwell. Court will set Mr. Solis then for docket call on January 8th at 1:30. And I appreciate you standing in, Mr. Smith.
No problem. Yeah. Samantha.
Court calls cause number CR 25-155 and CR 25-169, State versus Samantha Laverne, Maine, for docket call. Go ahead, Mr. Smith.
That's correct, Judge. We're going to ask for a final docket call on January 20th.
Any objections from the state?
None from the state, Your Honor.
All right, court sets Ms. Maine for final docket call July 20th in each case.
January 20th, Your Honor.
I'm sorry, what did I say? July? Is that what I said? I said July?
Yeah, yes.
Ms. Maine, you don't want to be sitting in the jail till July, do you?
No.
All right, then because Ms. Maine doesn't want to sit there till July, I'll make sure it's January.
Thanks, sir.
Thank you, Mr. Hartwell.
Huh? Yeah, all we gotta do really.
We're gonna do the extradition while Mr. Smith speaks with gets prepared for the writ hearing.
Okay, very well. All right, good afternoon, Ms. Hatley.
Hi. Oh, you can have a seat.
My name is Chris Martin. I'm the district judge here in Van Zandt County, and you are currently being held in the Van Zandt County Jail on a warrant from the 10th Judicial District Court, which is in Athens, Tennessee. Or
Yes, sir.
that area. And
Van
you
County, yes.
are wanted on a charge of theft of a motor vehicle over $2,500.
Yes, sir.
So I need to confirm some information from you. Your name is Crystal Annette Hatley, is that correct?
Yes, sir.
And Ms. Hatley, your date of birth, November of 77, is that correct?
Yes, sir.
Okay. And Ms. Abraham, will you just point out the defendant information on the warrant? I don't want to repeat her date of birth and all these things and her driver's license number. Will you show that to Ms. Hatley and have her confirm there in person if the information contained in the defendant information section on the arrest warrant is in fact her positive identification?
Driver's license.
Yep.
Date of birth, 7/26.
Yeah.
Okay,
Yes, sir.
so Ms. Hatley, you've reviewed that defendant information and you would tell me that that is your true and correct information.
Yes, sir.
Okay, all right, so Ms. Hatley, I've informed you that you're wanted in McMinn County, Tennessee for this charge. And so by virtue of you being here today, the state of Tennessee wants to know whether or not you are going to waive extradition or if you're going to require them to extradite you from the state of Texas. I believe that the jail staff gave you a document earlier called admonishments regarding waiver of extradition. Is that correct?
Yes, sir.
Did you read over that?
Yes, sir.
Did you understand what you read?
Yes, sir.
Do you understand that you have two options regarding extradition?
Yes, sir.
You can require the state of Tennessee to formally extradite you by way of governor's warrant, or you can waive that process and you can go back to Tennessee voluntarily. Is that your understanding of extradition?
Yes, sir.
And have you made a decision on what you would like to do?
Yes, sir.
Okay, what's your decision?
I'll waive it. That way I can get there. I've been here over 100 days already.
Okay. You've been here over 100 days?
Yes, sir. I've been here 114 days today.
Did you have another charge other than just this McMinn County?
They charged me with unlawful use of a motor vehicle when they arrested me on the 11th of August 11th. They charged me with the unauthorized use of a motor vehicle, and now McMinn County has this theft of a motor vehicle. So, I mean, it's the same thing. It's just worded different.
Okay, but were you prosecuted here? Did you?
Yes, sir. I have a PR bond from here on the 99th day I was in jail. I got a PR bond from here, so that was on the 19th when I got it. So I'm still just be sitting here waiting.
Have you been charged with that crime here formally in court? Have you gone to court on?
Yes, sir. Yes, sir.
Have you seen Judge Winters? Is that where you were going?
I think that's who the judge was. Yes, sir.
Was
But
he
my
coming?
lawyer.
Was he
He
coming
came
out
here.
to the jail? Yes. Okay.
Yeah.
And who's your lawyer in that case?
Wish I could remember his name. Stevens. Bill Stevens. Yes.
Okay. All right. So have you taken any kind of plea on that case or not?
I pled guilty, but like I've got a PR bond. I got the paper in my pocket right here showing that my PR bond on the 19th is when they gave it to me. So I've been steadily sitting here waiting for some kind of extradition because I knew I had that warrant. But I mean, and then they told me I had to come to court today. So it was news to me.
Do you think you pled guilty on
Yes,
that,
sir.
on the Van Zandt County charge?
Yes, sir.
Do you know Ms. Abraham? If she pled
I
guilty?
can go check.
Do you want to
get
see the
time-
paper?
No, did you get time served? Did you?
They gave me a PR bond because I'd been here over 90 days.
See, that's what's confusing to me. You're saying you pled guilty, but you wouldn't get a PR bond after pleading guilty. You would receive a sentence. You wouldn't be
They,
on bond.
Okay, well, I don't know how it
That's
works
okay.
here. Everything
It's
here
okay.
is so much different.
It's better here. I know. Sometimes better.
Is it better here?
Oh, it's a lot better here. Trust me. You're in the greatest county and in the best
That's
jail
what I hear.
whole state of Texas. Yeah, give me just 1 second here.
All right.
Ms. Hatley, and I will look up and see what exactly happens on your case here. I just want to make sure that I'm clear on what's going on before I send you to another
The
state.
first time I went to court, they didn't know. All they knew was my
name was on the docket. They didn't know my charges. They didn't know who my lawyer was. I sat there for 2 hours and they couldn't tell me anything. They had to look it all up. And so they put it off for a little over a month. And when I went back to court on the 19th, they gave me that PR bond. And so I've just been waiting ever since then for them to release me. I have no idea what's going on. All I know is I'm just sitting here idle.
Well, before you and I are done talking today, you're gonna know exactly what's going on. You're gonna know exactly
Okay.
what to expect.
Good.
You'll leave here knowing a lot more. So give me just
Sounds
one,
great.
yeah, give me 1 second. I'll be right back with you and we'll get you some information. Okay.
Okay.
Taquitos, like crispy those. Yeah.
That's what they call them in Texas.
Yeah, I wrote Texas, never heard of crispy.
It's like keto. What they call them at Walmart.
Oh, okay. That makes sense.
Oh, fair enough.
Oh, I got heard from my mom. She went my last time. 12 emails and things were on the phone. What happened with Dixon? What Dixon from the court today? You? David Dixon. Ain't so 16. I'll be doing 16. Is it? He's telling myself to chill out. You know him. Yeah, that. Tell myself to chill.
Hey, what did he say?
He'll be back.
For no 18 months again. So you're coming back?
Yeah, I did.
No, some very bad. No. Yeah, no, his ball is wearing, yeah, that sheet. No, come up, I get off pretty good. Yeah, both get free. Yeah. Easy.
Nice phone vibration.
Yeah, you said you're wrong. Yes, we're not. It's not helpful. Yeah, he thought he had court today. Coming.
So if you want to go ahead and initial, I will waive my right. And then sign, then he's trying to figure out about
Just
the,
initial it.
put your initial right here that you waive. Sign it.
I appreciate it. Yeah. No, I'm a
Judge will sign and then we'll send it back out here. Or not.
That gives me a good quick, right? Yes.
B, L, I, no. And
All right, Crystal, let's look here. So you see what I've got on the screen there?
Sir?
You see your booking information there?
Yes, sir.
Okay. So I'm gonna pull that down real quick. So, you have been charged with unauthorized use of a vehicle by the police department here in this county. And that case has not been indicted, it's not been filed in court, and you've not pled guilty. So
Okay.
you've been held on that. You have been granted a personal recognizance bond or a personal bond in the amount of $15,000. So that means that you are going to be eligible to be released to Tennessee. And so if you waive your extradition today, then you'll go back to Tennessee to address their charge of theft of property greater than 2,500, less than $30,000. So once you get there and you resolve that, you will still have a case here. Now, whether the state prosecutes that case or they don't prosecute that case is going to be up to them. If it's the
Okay.
same case out of Tennessee, they may not do it. They may not be interested in it. But if it's a different crime or a new crime that's alleged to have occurred here, then they may very well have to bring you back. But at this time, you've not pled guilty to that. You have been granted the personal bond. And if you waive your extradition today, you will be we'll notify Tennessee to come pick you up, and they can pick you up, bring you back, and then deal with you over there on your charges. And then you'll need to follow up with Van Zandt County.
Okay.
And make sure that if your address is different, that on your personal bond, you had to fill out your address. If that
Yes.
changes, you need to update Van Zandt County so that they can let you know if there's going to be a case. You'll get notice. If there's not going to be a case, you'll get notice there won't be a case. So it's in your best interest to stay in contact with your attorney here and make sure that your address is updated with the court. Okay.
Okay.
All right. And so just to conclude our extradition hearing, you have indicated that you want to waive your right to extradition. And
Yes, sir.
you've been apprised of what your rights are and that you're waiving your right to be extradited and you're willing to go back voluntarily.
Yes, sir.
All right, then Ms. Hatley, once you sign that form, Ms. Abraham will send it to me. I'll get it signed, and then we'll notify McMinn County in Tennessee that you're eligible for release to them. Okay.
Okay. Thank you.
All right. You're welcome. You have a good day.
Thank you, ma'am.
Mr. Smith, who would you like?
Christopher Seymour.
All right, Mr. Seymour.
Yes, sir.
This is writ number WR 25-51. Christopher Neil Seymour versus State of Texas. I believe that this is a writ seeking bail reduction. Is that correct?
Yeah,
Oh, sorry.
Judge, yes, this is an agreed writ seeking a PR bond 17-151. I believe the court has a proposed order with the state signature affixed thereto. For the purposes of this hearing, I'd call Mr. Seymour to answer questions.
All right, Mr. Seymour, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right. Court is going to allow testimony from you on the limited purpose of seeking bail reduction and for the bail factors that the court must consider in entertaining the agreed recommendation. Do you want to start with questions, Mr. Schmidt? Go ahead.
I will, Judge. Your name is Christopher Neil Seymour, correct?
It is.
And you were arrested in Denton County on this Van Zandt County charge of aggravated assault with a deadly weapon. Is that correct?
That was.
And you were arrested in Denton County on August the 21st. Is that correct?
That's correct, sir.
And have you been in custody continuously since August 21st?
I have.
Were you being held in Denton County on Denton County charges or just on Van Zandt County?
Van Zandt County only.
So you're being held only on Van Zandt County charges. Have you been in custody longer than 90 days prior to the state returning an indictment against you?
I have.
And it's my understanding that the state has returned an indictment on this charge, but it was after that 90 days had elapsed. Is that correct?
Yes, sir.
And that's based on my conversations with you today. Is that right?
Yes, sir.
And so you're asking the judge to grant you a personal bond while this case is pending, correct?
Yes, sir.
Where do you normally live, Mr. Seymour?
At 225 Natchez Street in Canton, Texas.
And do you have a vehicle?
I do.
Do you have the ability to get back and forth to court in order to make your court hearings, right?
Yes, sir.
And do you have a job waiting on you as well?
I do.
And you understand that if the judge grants your request, you will be assigned conditions of pretrial release, which will require you to follow certain rules, including meeting with the pretrial release officer, paying certain fees monthly. Are you able to do that?
Yes, sir.
As far as these charges are concerned, obviously, once your arraignment is set, you are going to plead not guilty, correct?
Yes, sir.
And you're aware that your wife, I believe, who is the alleged victim in this case, has been in contact with me pertaining to the allegations. Is that correct?
That's correct.
And we forwarded that information to the DA's office, and we fully expect that ultimately you to be exonerated of these charges, correct? Now, as of today, your bond is set at $250,000. You're unable to post that bond. Is that also correct?
Yes, sir.
And you've been found indigent by the court and appointed an attorney to represent you, so you don't have any property or any assets that you can sell to come up with that amount, do you?
No, sir.
Is there any amount short of a personal bond that you could post?
I have no means to any financial, any money that was coming to the household is now taking place of me not being there and covering the bills.
All right, so that answer is no.
The answer is no.
Yes, sir. Okay. And are you telling the court, or you're assuring the court that if you're granted your PR bond, that you can make it back and forth and follow the rules set for you?
Yes, sir. Most certainly.
Now, previously, the court has certain things that the court has to consider as far as public safety is concerned. Now, I'm sure that the state or even the court will ask you about prior criminal charges. And I've informed you that you're not to answer those questions based on the fact that this is under oath. You are indicted, and ultimately anything you say along those lines can and will be used against you at any subsequent trial that you have. Is that correct?
That's correct.
So if you're asked that question and you refuse to answer it in this hearing, you're not being rude to the court or to the DA's office by doing so. Is that correct?
That's most certainly correct. Yes, sir.
I'll pass the witness.
State.
Mr. Seymour, if the court were ordered you to live somewhere other than your home, to have no contact with the victim, would that be any kind of problem for you?
No, sir.
So you have another place to reside if you were ordered to stay away?
I do.
And Your Honor, with Mr. Schmidt's instructions not to answer criminal history, would the court prefer that I proffer criminal history since the court has to consider it?
Yes, sir, please.
Yes, sir. 1994, a felony theft conviction. 1994, a felony assault of a public servant conviction. 2008, a felony harassment conviction. 2007, a misdemeanor criminal mischief conviction. 2006, a Class B DWI conviction. 2008, an obstruction or retaliation conviction. 2007, a failure to ID conviction. 2009, possession of a controlled substance in PG1 state jail conviction. 2008, an assault family violence conviction. Also in 2008, a resisting arrest conviction. 2011, DWI second conviction. Also in 2011, a misdemeanor criminal mischief conviction. 2014, a misdemeanor harassment conviction. Also 2014, an assault family violence conviction. And that appears to be everything, Your Honor.
Okay, and Mr. Hartwell, can you address the future safety of the alleged victim and the general public with regards to whatever he's accused here of aggravated assault with a deadly weapon, but I don't have any of the information relative to the accusation, but can you tell me?
And Judge, I'd be happy to address that for the court if you'd like. I've been in frequent contact with the alleged victim. I've received information in writing from her that I've forwarded to Mr. Hartwell, and I spoke with her on the phone, last week. And she's asserted to me that she believes that this was an accident and she has no fear or worry about Mr. Seymour being released on a PR bond. And I'd state that as an officer of the court.
What's the nature of the accusation so that I can understand?
It was a vehicle collision.
One vehicle.
In other words, yeah, that's correct.
Person.
Yes, sir.
Vehicle to vehicle or vehicle to person?
Vehicle to vehicle is my understanding.
Mr. Hartwell, you concur?
Yes, Your Honor. That's what's contained in the indictment is vehicle to vehicle.
Okay. All right, and Mr. Hartwell, have you received that information that Mr. Schmidt has forwarded regarding the victim's stance on the request for a personal bond?
I have, Your Honor.
Okay, and you're in concurrence with Mr. Schmidt's recommendation?
State is, Your Honor.
Okay, all right, then the court will take that under consideration and issue a ruling at the conclusion of the docket.
Thanks, sir.
Your Honor, it will be just a moment. We're getting Mr. Creel.
Okay, do we still have a writ on Miss Clow, Jessica Clow?
No, the state rejected the case.
Okay,
Yes, Your Honor. If the court would like more information on that, I can give the court some information, some background.
no, that's okay. If it's been rejected, then I just need Mr. Schmidt to withdraw his writ non-suited, and then I can close it out.
And
Yes.
Judge, I would make an oral motion to non-suit, and I don't know if that case is on the record been called, but I received a copy of the state's rejection notice as well. Yeah, today.
All right, WR 25-46, Jessica Lynette Clow versus State of Texas. Court finds that an oral motion being made to withdraw the writ is granted. Court finds the basis is rejection of the case for prosecution by the DA's office. Court will issue an order non-suiting that case.
And Judge, on Mr. Creel, they're bringing him up. I know that you gave me an oral granting of funds for an expert to retain for the psychological issues. I did go ahead and file a written motion with a proposed order. I haven't seen whether or not that written order has been granted, but just to update the court prior to him coming in, I'm trying to track down an expert that will or can accomplish the issues that we have. I've used a different expert in the past, which I cannot use him for these particular purposes. So just as an update, we're still looking.
Obviously. I don't wanna.
All right, court calls, cause numbers 2025-92, 2025-98, CR 23-158, CR 24-206, State of Texas versus Brandon Ashley Cruel. I believe that we're set today on status for the requested evaluation.
Oh, that's correct, Judge. Basically what I did request funds. And we're attempting to retain a forensic psychiatrist or psychologist who can do evaluations for the purposes of the insanity defense. We're still trying to track an expert who is available to do that. We're going to ask for another status reset on that.
Right, court will grant the request. The court will reset Mr. Krill in all cases. I know that's going to take you some time, Mr. Schmidt, so I'm going to look at February,
Yes, sir.
about February 17th.
You want to sign?
And Mr. Schmidt, I have gone into e-file and signed your order on the funds.
Thank you, sir.
There's just one order, correct?
Yes, sir.
Okay, so I've got that signed and I've sent that back to Ms. Taberham, so it'll be back to you probably this afternoon or tomorrow at the latest.
Appreciate it.
All right, thank you, Mr. Krill.
Maybe I'm thinking he does the thing.
Just right.
Ms. Taberham, anything else at the jail?
No, sir.
Right, and that concludes the court's afternoon criminal docket. I appreciate everyone's work today. It's adjourned.
Thank you, Rob.
Thanks, sir.
Wait, we gotta get out of here first. We have to log out of